So a little bit about myself. I am Roberto Seda. I graduated from Lawton Mac in 1996, a long time ago. I am here because of the military. My dad was in the Army, retired I think after 20 years, and then was in DFAS for 10 years. So you may or may not know him. I believe Kim in the back does know my dad. I didn't know if they would spontaneously show up this morning from Fort Worth or not, because they did get the email that I was going to be presenting for Fort Sill. I believe I am a member of Fort Sill Federal Credit Union. I may have like $10 in the account, right? Something like that. My mom put enough to make sure that I was in good standing. But that's I lived here for a while. In 1996, I moved to Stillwater to get my engineering degree. I did work after graduating from Oklahoma State. I worked at General Motors in Midwest City for a while until they closed that plant down, which at that time went to Tulsa to work for a company called Spirit Aerosystems that I believe now may have gotten bought out by Boeing. At the young age of 30, decided to go back to law school, thinking I was going to do some patent work because of my engineering degree. Passed the patent bar, ended up I went into oil and gas, and then around 2019. After writing a bunch of title opinions, decided I want to go on my own and made a pivot to doing probate and estate planning. That's been my primary focus since that time. At my firm right now, we currently have 10 people, including myself. So we've grown, had a lot of growth in Oklahoma City. I do have a satellite location where if you contact us and say we want to meet with you in person, right? Because a lot of times people want to, I'm old school. I want to meet the person, right? So who I'm going to be working with, and as long as we get that put on the calendar, we do come down and meet with people, whether it's an initial consult or a signing or whatever it may be. I am based out of the Chamber of Commerce. All right, so if you drive by on Gore and the Chamber of Commerce, my sign is up there. I do rent an office there, and that's where we would meet if we needed to. But we are based out of Oklahoma City primarily, because that's where I've got my family. So let's talk about some estate planning. I do believe that estate planning is for everyone, all right? And throughout this presentation, I will give you examples of experiences that I've had both on the estate planning but also the probate side of things. But it is one of the most important gifts that you can give to your family, and I will give you guys reasons why. Before I get started, I start every presentation with this because I feel like it gets me in the right mindset. I do tell dad jokes. So whether it's networking or presentations, I do have a couple of dad jokes for you guys. What do you call a priest that becomes an attorney? Anyone? A father-in-law. All right, so, or where do dads store their dad jokes? In a database. Right, so I think someone in the back may have known that one, but I know they're terrible. My wife cringes every time that we go to a networking event together, and she's like, please don't tell a dad joke, right? But I'm known for them. I went to a restaurant one time, and the server, I was trying to pick her out, she's like, oh, we were at that networking event. You're the guy that's an attorney with the bad dad jokes. I was like, yep, that's me, right? So I may be your atypical attorney. I do have a sense of humor. So, all right, so some of the topics that we're going to discuss today is how to maximize the inheritance that you leave to your children. All right, oftentimes people want to make sure that the state doesn't take everything, right? Or I'll give you guys some examples of some probates gone wrong through these presentations. Some of the pitfalls of putting your assets into your children's names, right? So a lot of times I'm talking to somebody, I was like, oh, well, I just added my kid to the title, right? I'll give you reasons why that may not be a good idea. I will discuss the difference between a will and a trust. Now, because I get a lot of times I'm talking to people and they're like, well, I've got a will, that's good enough. I was like, I'm going to tell you why it's not good enough, from an attorney standpoint, right? How to avoid the expenses and delays of probate. I don't know if people have dealt with probate here. I will explain what it is and the downfalls that your family's going to suffer as a result of going through probate. How to keep your affairs private. Probate's very public, right? And I'll give some examples there. And then how to protect yourself in the event of a disability. If you were to go into the hospital today and we're incapacitated for a long period of time, who's going to make decisions on your behalf, all right? So we'll talk a little bit about that. So let's talk about some common estate planning questions that I always get. I've sat down with people who are interested in doing an estate plan. They say, what is an estate plan? So my definition of an estate plan is a comprehensive estate plan that includes the following, all right? So if you can think about this, everyone has an estate, all right? Your estate consists of everything that you own, all right? So if you're a 19-year-old kid and mom and dad bought you that Ford Mustang, and that's all you own, that's all that's in your name, that's your estate. Or fast forward, us more seasoned adults at this point probably own a house, bank accounts, some retirement accounts, life insurance. All of that together is our estate. If when you pass away, those assets are in your name individually, right? So if I passed away and it's in my name, Roberto's name, then and there's no other planning, at that point, we would have to probate my estate. We would have to go through the court system to pass it down to my kids. I'm married. Right now, part of it would go to my wife, part would go to my kids. Otherwise, I can be proactive and actually make a plan, put a plan in place for my estate. That's where estate planning comes in, all right? So an estate plan consists of two factors. We want to talk about incapacity planning. So if you were, in the event that you were incapacitated, right? For most people here, you're younger, the incapacity would probably come if you were in the hospital, right? As we age and you're having to face dementia, Alzheimer's, right? At some point, you're going to be deemed incapacitated. In those situations, if you are incapacitated, who's going to make those medical decisions for you? What are your end-of-life wishes, right? If you're in the hospital and you're in the emergency room and the doctors have come in and said, Roberto's got less than 2 months to live. Do I really want to be kept on life support, or do I want to, for a lack of a better term, have the plug pulled on me, right? So we have that discussion. And then who's going to manage your money? In the event, and your property, in the event that you are incapacitated. So we're having this discussion because you know your family best. If you've got your 3 children, do you trust all 3 to make that decision for you? I see some people laughing, right? Maybe that's one person that's better, you feel would be better at making medical decisions for you. Is there one that's better at making financial decisions for you, right? These don't have to be the same people. So we want to have that discussion so that we can take that and actually put that on paper, right? And have that paperwork filled out in a way that it's going to have some legal backing, right? Because without it, if there's nothing in place, then you're going to the courts and saying, Judge, can you appoint somebody to make medical decisions? Or your family. Your family's applying to have the judge appoint them. And it may not be that kid that's very financially sound. It may not be that kid that can make medical decisions on your behalf, right? So, but they would be going through the court process. That's called guardianship. All right, so I'm going to throw a lot of numbers out. I just signed up a guardianship matter. We opened one up yesterday. $3,000 for one person to get appointed to make decisions on behalf of the ward being either the parent or whoever it may be, right? So it's a very costly process even for guardianship. So why not be proactive and get your paperwork put in place beforehand so you can avoid that? Through that process, you may have somebody that you think would be a good primary person, right? But if they pass away, who's going to be the backup, right? So we have discussions as to, I like to at least have 3, and I call them decision makers. So I like to name at least 3 decision makers on all of your incapacity documents, right? Your POAs. So we're talking about financial power of attorney, medical power of attorney. We will talk about advanced healthcare directives. Those are the types of discussions, and they're not easy discussions, I'll be honest with you, right? But we do have discussions. Then we talk about your comprehensive estate plan is going to include death planning, all right? So when you pass away, you have a say on where your stuff is going, right? Who's going to get it, right? And at what point? You know, maybe if you've got minor kids, you can make a decision. I don't want them getting everything when they turn 18. So there's some things that we'll talk about. Then I get the question, well, what if I don't do an estate plan, right? It's easiest not to do anything, right? You do have to be proactive. You have to take the time out to do it. It does cost money to put an estate plan together. So what if I don't do anything? Well, everyone has one, right? If you're not proactive and put something on paper, then you're going to default to what the state has deemed, right? And so this is where it can get pretty messy, right? If you've got blended families, now you get the stepmom fighting with the stepchildren. I've had that happen, right? And, or I had one, a probate and more, where it was a house. The house got sold through the probate, $160,000 net. That's the only thing that went through the probate. We're now splitting $160,000 between brother and sister. How much are they getting? Well, they fought all the way through. At the end of the day, $45,000 in attorney's fees, right? So almost a third of that estate was eaten up by attorneys. Now look, I'm an attorney, I have a business. If I wanted to maximize what our revenue was, I do probates all day long, all right? The regular administration and regular probate in Oklahoma to start up my firm is $5,000. Because in my experience, it costs $4,500 to $5,000 if it's uncontested. If it becomes contested, then it just skyrockets from there. I did a probate in Oklahoma County once. When it left my firm, we were at $46,000. I think when it finished up, it was about an $86,000 probate. Now there was about $600,000 in the estate, so the estate still had money that got split up. Now this person died with no kids, no siblings, no spouse, no parents. If you can believe it or not, we had to draw out a family tree that we had on my office. 65 people got to split that estate. That's how far out. We're going to second cousins once removed, right? And so that was part of it. And in that situation, the sad part is the person who passed away was befriended by a friend's daughter, who then got a POA, you know, and it was fraudulent, went to the bank, got herself added on the bank account, started transferring money out to herself, started selling property. It was very complicated, as you can imagine, but that's what happens. If there's no planning, then you've got people that are going to try to create documents. I've got in Shawnee, I've got a probate that right now we're trying to figure out if a will was forged by the surviving girlfriend, basically. And so that's going to be a mess. I've got trial on that next month. So let's talk about what the state default is, right? If I pass away, my wife gets half. Automatically, the other half goes to the kids. I had one matter in Moore, again. Mom, the husband was the only one on title. He passed away. He had a surviving spouse and one child, a minor kid, right? I think the minor kid was like 7 or 8. Well, when he passed away, half went to the spouse and the other one went to the minor. Now when they go to sell the house, not only did she have to do probate, now when they go to sell the house, she's got to be appointed the legal guardian of her child to then sell the home. So she spent $4,000 or $5,000 on the probate. She's going to spend $3,000 to be appointed the guardian of her minor child. So she's going to end up spending close to $8-10 grand when all said and done to just sell the house, right? Because there was no planning, right? And so they say it's good to have these conversations so that your family is not dealing with this after the fact. So if you're using the state's default, the court will decide who's going to make medical and financial decisions for you, who gets your stuff and when they get it, and who's going to take care of your minor children, right? At least through these documents, you can appoint somebody. I'm going to nominate my sister, right? And that bears a lot of weight in front of in the court's eyes. So what is probate? I talked about it. Probate's just going through the legal process, right? Going before a judge. So you may need a probate if you die owning accounts or property in your name only, with or without a will. All right, so a will does not keep you out of probate. If you can think about this, a will needs to be found to be valid, and the only way that you can get a will before the judge is to open up a probate, and then you've got to set a hearing date for that to be heard. So a will does not keep you out of probate. So if you do or you do not have one, then we're looking at what did you own when you passed away. All right, so that 19-year-old with that Ford Mustang, if it's worth $5,000, it's not going to go through probate. All right, when we're talking about personal property, $50,000 is the marker. If you're above $50,000 in personal property, then it has to go through probate. All right, so if you've got, if the only thing you have is, a $10,000 car and $50,000 in the bank or $45,000 in the bank, you're over that marker. Your family's going to be going through probate. All right, if you don't have any personal property, let's say the only thing you own is real property, your home, that's the only thing, it's going through probate regardless of what the value is. All right, mineral interest, if you own mineral interest, it's going to go through probate. That's where my oil and gas experience really really guided me going towards probate and estate planning, because I had to make a lot of requirements in my title opinions of somebody owning 0.05 of a net mineral acre that may only be worth a couple $100. It's got to go through probate, at some point. So real property, whether it's a $25,000 house or a $500,000 house, it's going to go through probate. So just know that. All right. So those are the qualifiers. So probate's just the court process that determines whether you have a valid will. And so that, like I said, we're contesting one in Shawnee. Who's going to be appointed to wind up your affairs, right? If you don't appoint somebody through your will, then there's a statutory order, right? The state has deemed here's who has priority in order to represent your estate. And who's going to get your stuff? All right, so that's the big one. I think a lot of people, I think that's where they are most concerned. I did an estate plan earlier this year for a family in Norman. All right, I haven't really talked about the estate planning side, but they have a $3 million estate. They had 3 kids. When we met with them, they said, we don't want to leave a dime to our 3 kids. We haven't seen them in 17 years, right? Haven't seen them in 17 years. We don't want to leave them anything. And they said, what can we do? Well, you don't want to leave it in a will, because if they said in the will, you're not getting a dime, we're giving everything to charity, which is what the choice that they made. In a will, they could contest that, right? Because a will is submitted to the court, and then all the beneficiaries, the kids, are entitled to notice, and they can come in and say, hey, I think that will is invalid, right? So what we did is we set up a trust. We put it in the trust. When they pass away, when they both pass, then it's going to charity, right? The good thing about the trust, if they change their mind in the future, they can change it. All right. Let's say one of those 3 kids ends up, making amends, and they come back in. They says, you know what? Maybe we'll leave them $500,000, whatever it may be. They can update it. All right. So that's the beauty of a trust versus a will. But don't leave it to the state to determine who's getting your stuff. All right. The downside to probate, it is expensive. A regular probate, you start at $5,000, right? Now, if that probate ended up being $4,500, I would refund that $500, right? But in my experience, the $5,000 is usually at least a minimum of what we see for a regular probate. There is a shorter probate if the estate's under $200,000 and we can get all the waivers. There's a lot of things a lot of boxes that would need to be checked off, but it starts at $4,000, right? So either way, you're spending at least $4,000. So it is expensive. It's a matter of public record. It is time consuming. I've had some probates that have been open for a couple of years. We've picked some up that people want us to finish that were opened up like in 2009, right? It just, movement stopped, right? And so we're picking it up to finish them up. And it is a matter of public record. So your will, where you're disinheriting your 3 kids of their $3 million estate, will become a matter of public record. That's why we can read the stories of Aretha Franklin and all her wills, right? That's public. Or Prince, you know, his affairs were public, right? Because they didn't have a trust put in place, right? I had one will many years ago where it was handwritten, and mom said, I'm leaving $10 to her son. She says, this is the last beer I'm gonna buy you, right? And then I forgot where it left everything else to, but that's public record. So it is a very public process. So we talked about, can you add your kid as a joint owner? This is very common. And that is a way to do it, right? You can add a kid to the bank account. Now what happens? That bank account, if your child gets in a wreck and they get sued and there's a judgment against it, they now co-own your account with you, right? If you have got $50,000 in there and there's a $50,000 judgment, they can come after your bank account now, despite you didn't have anything to do with that wreck or whatever led to that judgment. So it is vulnerable to the joint owners, to the kids' creditors, and they're a co-owner. So let's talk about, I added my kid to the property, to the house. That's common. Same thing as far as the creditors, but let's say now you want to sell the house. Now your child, who's now entitled with you, has to sign off on all this paperwork. And what if they don't want to sign off? Now you're going to court to go force them to sell the house, right? And now you're just paying. The only people that went through court, y'all, is the attorney, right? Stay out of it if you can. And that's where I say, and we talk to families every week, and it's tragic what we hear. And it's just like, you know, we can help you, right? If they're still alive, or if we're dealing with probate, it's like this could have been avoided. Can you fill out a transfer on death deed or a payable on death, right? We all have our bank accounts that name somebody. That is a way, right? I'm not saying that don't do that, but what I have seen is there was a mom that created a trust, had her POA, did everything, put everything into her trust, but she forgot to change her payable on death on her life insurance, right? So when she passed away, the life insurance company said, who's entitled to the $75,000? Daughter is. Oh, daughter died before mom did. She never updated that. So now we get a call to probate, again, $75,000, that's the only personal property. It's above $50,000, we're going through probate. So $75,000, she had a pour-over will, and I'll discuss what that is, that puts it into her trust. That $75,000 life insurance policy still costs $4,000 to go through probate, right? So it works until it doesn't work, right? And when we sit down and have conversations with our clients, we say, take that life insurance policy and you're going to update the beneficiary to be the trust, right? So when you pass away, everything's going into the trust. And so that's my big thing on payable on death. It's, if you're naming somebody who can die, you never know when they may pass away. It's common to do a transfer on death deed on your home. I've used it before in certain very specific circumstances. I'm not a fan of them, because what happens is, if you've got a transfer on death deed, you pass away, you name it, let's say you leave it to your 3 kids. Your 3 kids now have 9 months to file an affidavit saying, I accept my interest. And if one of the 3 kids fails to do that, let's say one of them fails to file that affidavit, that 1/3 of that interest in that property is going to revert back to you. Now it's got to go through probate. And I've seen that before, to where the person failed to accept within 9 months. They're like, well, we just didn't know. So, and that's not enough to say, well, because you didn't know, you get to keep it. So we've had to probate real property, homes, because of a failure for the affidavit to be accepted. All right, so what are some estate planning solutions? Creating a revocable living trust. All right, this is what I've done for my family, right, as an attorney. I feel like this is the best way to do it. It's an investment that you're making in your family. But let's say here we're creating the Smith Family Trust, right? And your goal is to put everything into the Smith Family Trust, all right? But through this process, we sit down and decide who's going to manage that. Who's going to manage your trust, all right? Because when you create it and you put everything into the trust, at some point, you no longer own anything. Your trust owns everything, right? But because you own your trust, you still own everything that the trust owns, right? You have to, in your brain, you just kind of have to separate that your trust owns it, not you personally. But you're going to be named who's going to manage your trust, right? Initially, a lot of people it's going to be them, right? You don't want to release that control. But when you pass away, who's going to take over, right? Who's going to step into your shoes and manage your trust for you? Through your trust, you're going to say, okay, who's going to benefit from the trust assets? Again, during your lifetime, it's going to be you. But when you pass away, who are your loved ones that you want to leave your stuff to? Right? So we have that type of discussion. What's going to go into your trust? Your home, your real estate, your bank accounts. Those are things that you're going to retitle into. Right, so when we sign all paperwork, a lot of times we're doing the deed to put the home into the trust. Then we give them instructions. We will give you instructions to say, go to your bank, take your bank account, and retitle your bank account in the name of the trust. So we do ask a lot of information. We want to know your assets because we want to make sure to give you good funding. We call that funding. Funding is when you take it from outside the trust and put it into the trust. We're going to give you instructions on how to retitle everything. For life insurance, it's a personal asset. We say life insurance, you're going to update the beneficiary to be the trust. So we'll work with you guys through this whole. Retirement accounts do not go into the trust, all right? Retirement accounts, another one, payable on death. If you're married, you're actually going to name your spouse first and the trust second, right? So we'll help you through this whole process. And we'll explain why that is. But let's say you get that trust set up, you put everything into it that you need to, right? What happens when you pass away? Your successor steps in. And then now they're going to read your trust, right, your document, and say, okay, Roberto's passed away, where is this stuff going to go, right? Who gets it? And so that's where that successor trustee will figure out who your beneficiaries are going to be, right? The goal here is that with your home or your bank account, it's going to pass down to your beneficiaries, and you're going to be able to avoid probate court, all right? Now, it's real critical to understand that your trust is only as good as what you put into it. All right, so that mom that put everything into her trust, except she forgot to update her life insurance, she still had to go through probate. But the goal is, whether your trust owns your asset during your lifetime or is a payable on death like life insurance, if you miss something, you've got your pour-over will that puts it into your trust. There's peace of mind in knowing that your trust is going to distribute your asset at one point or another. Right? Everything flows through the trust. So what does that mean? That means that, let's say, we're here in 2025, I'm leaving, if it was just me individually, I'm leaving my stuff to my 3 kids. 5 years from now, one of my kids ticks me off and I decide I don't want to leave them anything, right? I've got 3 sons and I say I want to remove them from my bank account as a beneficiary. Well, I've also got to do it for my life insurance. I've got to do it for my retirement account. All right, there's so many different places that you need to go to. With a trust, you name everything goes to the trust. You got one place to make those updates. All right, and you can make those updates. Because it is revocable, it means you can amend it at any time. So my wife and I created a trust several years ago, and we're leaving everything to our 3 kids. So we updated in the fall because we realized that my 21-year-old that I have, as mature as he is, I'm like, he's really young. I'm not sure I want him getting a dime right now. I want to increase that age. So we updated it. Now they get it at 25, 30, and 35. In 5 years, we may change that. I don't know. I wanted to cut out my middle son. My wife was like, no, I'm not there yet, right? So I'm still working on her. He's coming around, right? I love my middle son. He meets people at where they're at. He's also my kid that tanked his GPA because he didn't turn some homework in at an OCCC concurrent course, right? So then he realized, he's like, well, how am I going to pay for college? And I was like, well, you're going to have to make a 35 on the ACT. He's like, okay. So he did that in February. Now he's got a full academic right to OSU. And I'm like, you've got the potential, son. So I've got very smart kids, and they're all good, but he was really testing my patience. Let's just say that, right? So other important reasons for estate planning, we talked about if you've got minor children, you get to designate who the guardian's going to be, right? So if you don't want your parents, let's say, to be the guardians if something happened to you and your husband, and you've got minor kids, you can say, well, I want my sister, right? That nomination is going to be huge in the eyes of the court. And we do this through your last will and testament, your pour-over will, all right, that we put together for you guys. Protecting your child's inheritance, right? So we talked about how do you maximize the inheritance that they're going to get? How do you make sure that it's not squandered? A, by not going through probate, right? If you can imagine that home, had it been sold for $160,000, split between brother and sister, they would have gotten close to $80,000. Instead, they're splitting, I guess I'm trying to do math here on the fly, $115,000, right? $45,000 less, So if you want to maximize what you pass down, you want to avoid probate. The other way is, if you don't take any action and you've got minor kids, when they turn 18, at that point they're entitled to their share, right? And I don't know about you, I thought I was a smart kid. I thought I was responsible at 21, and I realized I hit 25, I was like, man, now I can tell I'm really hitting my stride at 25, not 21, right? So, but those 18-year-olds are going to get their money, and what are they going to do? They're going to spend it on a PS5 or the latest iPhone, right? Or a brand new car, whatever it may be, right? They're not making smart choices, or most of them. I don't want to put a blanket statement out there that they're not all responsible. Some are, but a lot of kids have a lot of growing up to do. So we can say what ages they're going to get it. I had a client that I helped in the fall. Her husband passed away in August. That's what prompted her to reach out to the firm. I met with her in October. They had a 1-year-old, right? Her husband was a doctor. She's a doctor. In their late 30s, accumulated a net worth of about $4 million by their late 30s. If she passed away, you can imagine what $4 million would be like in 17 years when a 1-year-old turned 18. Could you imagine an 18-year-old coming into a $5, $6, $7 million inheritance? Las Vegas, right? I would not trust myself in Vegas. The only way I would go if I took my JD. We did a fundraiser. We did a fundraiser a couple weeks ago for the Moore Chamber of Commerce Foundation, and she took $100 and made it $1,500 at the craps table. So,
y'all want to go? Let me know.
So she's the one. But for the most part, you want to set those ages out. What that client decided to do, she did 5 ages, right? A little bit at 18, a little bit 21, 25, 30, and 35, I think, somewhere in there. This is specific to you, what you want, right? We like to sit down and say, ideally today in 2025, if you pass away, how do you want your stuff distributed, right? And it can be changed. Minors receive everything at 18, the age of majority here in the state of Oklahoma. So this is why trust is useful, because you choose who's going to manage your trust, right? And then you can say, at these ages or at these events, you're going to get your money, right? So you decide when and if and when they can receive. You can also say, I don't want them getting a dime until 25, but I want to pay for their college, right? We put language in there that says, if they go to college, they can go to the trustee and say, can you pay for my bursar bill, right? So we do provide some flexibility. It is not going to be rigid. So just know that. Other people that may need help protecting themselves from their inheritance. Someone who's bad at managing money, right? You don't ever have to give it to them. You can leave it in the trust while they're alive and say, I'm going to give you $5,000 a year or a couple $1,000s a month, but you're never going to get the $500,000 in whole, right? So someone who may need protecting, who's bad at managing money, maybe you only want to give them a certain amount. And then when they pass away, it can go to the grandkids or it can go to someone else, right? Individuals who have outstanding creditors and debts, right? Once it becomes there, if you give it to them outright, if it becomes theirs, it's subject to creditors, right? So if you leave it in the trust and you say you're never entitled, you've got to approach your trustee, the successor trustee for that money. That's a way to protect that money from their creditors. A person who has an occupation of high risk of lawsuits, right? Doctors, maybe attorneys, if they've got a business, maybe like, I'm not sure. They're just starting that business up. I'm going to leave it here for now, and set out the rules under which they can ask for that money. And then an individual who may be in a bad marriage, right? If it becomes theirs, then it's subject to equitable distribution in divorce court, and you're like, no, we're not going to make it available to you. Maybe you want that evil daughter or evil son, right? So that's a way to protect the inheritance for your family. Blended families, right? That's very common. What happens, if you can think about it this way, if you've got a blended family who's bought a house, a lot of times people buy it as joint tenants. That's a way to avoid probate. That only works until the first one passes away, right? So know that. But let's say husband has 2 kids, wife has 2 kids. Now you're playing who's going to die first. Because if the husband dies first, it goes to the wife, and then the wife dies, it goes to her 2 kids. But if the wife dies first, the husband's 2 kids eventually will inherit the house, right? So you're not protecting that. Maybe that's not the way they would have wanted it, right? But in your trust, you can define those terms. So you could accidentally disinherit your children, right, by being the first to die. If you've got special needs children, and they're receiving SSI, we can put language in your trust so that you can leave them a share, but it's going to be retained in the trust so that you don't disqualify them accidentally, right? I've got a probate right now where the sole beneficiary is special needs, living in Connecticut. His dad lived here in Oklahoma. We're having to get a Connecticut special needs trust set up so that Oklahoma court can put it into that special needs trust so we don't disqualify him from those governmental benefits. Let's see, if you own a pet, we can put language in there actually for your pet. Who's going to be your pet's caretaker? How much do you want to give to them? I did have a client in Norman, had 9 cats. She was in her late 20s, and she's like, these are my children. And she wanted to make sure that, for now, they're getting everything. They're going to be protected, right, for whether the cats are alive. And then after they pass away, then we're distributing it out. And this is actually if you own a business. The next slide is about pets. Sorry about that. If you own a business, just know that you need to be proactive. You've got your personal estate plan. You also need to do business estate planning, I call it, right? Your documents have to say where your stuff is going, who's able to manage your business, right? If I were to pass away, who's going to manage the firm? My wife can't take over. She's not an attorney, right? So having a plan, all those contingencies are always important. Now we're talking about the pet. So who's going to care for your pet? How much are they going to get? There's a lot of questions. We have a lot of discussions, and it is very personal, and we realize that. But I think that the good thing about working with like my firm or a firm that concentrates on estate planning is that we know what questions to ask. We've been doing this long enough. We've helped hundreds of people at this point, right? I don't do family law. You've got your generalists, right? People that dabble in all the areas, and I don't dabble. You don't want me as your family law attorney. You're going to lose the house and the kids, right? You don't want me as your criminal law attorney because you're going to end up doing 20 in jail, right? So, but I can help you on the probate and estate planning side of things because we've helped so many. I've helped someone in Lawton a couple years ago had $100,000. That's all she had. I said, you don't have to. I mean, do you want to do a trust, right? And she said, yes, it's going to go through probate. She had 1 kid. She's like, I don't want him getting everything. I want half of it to go to my goddaughter. So we did a trust. So that, because she could have done that in a will, right? And then the son would have contested the will. Now that inheritance that's getting passed down is going to become even less, right? Is there anything going to be left over at the end of all that? So we did a trust for her where half goes to the son, half goes to the goddaughter. So it's low, as low as $100,000. But I've also helped clients. We're helping clients that have 8, 10, 12 million, right? We're trying to figure out where do they want their assets to go, right? So it's a broad spectrum of people that we've helped because that's just all we do day in and day out. So some other estate planning documents that I feel are important. Your pour-over will. Now you may be asking Roberto, but you said a will is not good, right? It's got to go through probate. Well, the pour-over will is special because it says if I miss something, it gets put into the trust. So that mom that had that $75,000 life insurance policy, she had a pour-over will. Everything in that probate, that life insurance got put into the trust. So that's the big takeaway from this one. Powers of attorney, I mentioned it. If you are incapacitated, who's going to make that financial decision for you? Who's going to make the medical decisions for you? And so we want to have that discussion. Your financial power of attorney is durable, meaning if you are incapacitated, it survives. All right, the statutory does not provide for that. It also can be immediately. We'll have discussion. Do you want your power of attorney to be effective when you sign or only upon the event that you're deemed incapacitated? Right? Some people feel better knowing that their son can't write a check for them today. But if they are incapacitated, then they can at that point. So we'll ask those types of questions. Medical, right? If you're not able to communicate your medical decisions, right, someone's appointed there to do so. Your living wills and advanced healthcare directives, these are end-of-life choices, right? Everyone thinks differently, right? If I'm on life support, don't. I want to be kept on life support, right? For me personally, I've said if I'm that bad of shape, pull the plug. Let me be, right? I am a Christian. I believe that I've got, there's an afterlife for me. Let me be with my Savior. This is different from a DNR, right? But if you are interested in a DNR, we can print one out and execute that with all the other documents. But these are end-of-life choices. And then once you do pass, do you want to donate your body? Do you want to donate specific organs for medical research or transplantation? So we'll put all of that down on paper, all right? So as we wrap up here, here's some of the questions that I talked about. How to maximize your inheritance to leave to your children. Avoid probate, right? That's the biggest one. Just putting a plan in place. The money that your family is going to spend in probate, I can assure you is probably more than what you're going to spend on your estate plan for all of those documents that we talked about. All right. The pitfalls of putting assets into your children's names. We talked about that, if it's a bank account that, creditors can come in, or if it's a home, you would have to have them sign off, right? So those aren't things that you want to address, to have to go through. The other thing that we have not talked about is on a home, if you've bought and sold homes, you always talk about, well, what's your capital gains, right? There's some people have held their homes on, have owned it since 1965, let's say. You may have paid $50,000 back in 1965. That home is now worth $250,000, let's say. If you sold it, you would have an exemption, right? Personally, I believe it's like $250,000, but I would advise going to your CPA. But you personally would have $250,000. When you passed away and your kids get it, through court, they would take it at $250,000, right? So if they sold it to $250,000, they're not playing that equation of like that $200,000 in capital gains. But if you add your child during your lifetime, right? So you took it at $50,000, you added your child's going to get that $50,000 for their 1/2. When they go sell, they're going to have to pay capital gains on their 1/2, right? So it's better to pass it down to the kids after you pass away. And the best way to do that is to put it into a trust, then pass it down to the kids, because you're going to be able to get that step. It's called a step up in basis, all right? So just know that that's another way to maximize that inheritance that I failed to discuss. We talked about the difference between a will and a trust. A trust is a legal entity that can hold title to all of your assets. And if it does, when you pass away, you're avoiding probate. A will does not avoid probate. Talked about the expenses, probate, no matter what, your family's spending at least $4,000, if not $5,000 or more if it's contested. The delays could be as simple as 2 to 3 months. If it's a short probate, it could be years if it's a longer regular probate. Your affairs are public, so the way you want to keep it private is by putting a trust together. You don't take your trust and go file it with the courts. You don't have to file it anywhere. This is for you to keep at home, and you can change it whenever you want, right? And then how to protect yourself in the event of disability. You don't want your kids fighting over the money. Someone's going to take control of the car, sell the house, whatever it may be, right? You want to do that. Have your POAs in place so that does not happen. What questions do you guys have? Yes?
We already talked about once the trust is completed, you no longer own the properties?
Right. So
how's it work with taxes and titles and things like that?
Great question. All right. So the question is because we are being recorded, so I'm going to repeat the question. So the question is, once you create your trust and you put everything into your trust, right? What does that picture look like, right? As far as taxes, income taxes, and all of that. Your trust, your EIN number, your tax ID number for your trust is your social, all right? So nothing really changes other than the ownership aspect in your brain, right? I still log on to my checks are still in my individual name, right? But I do accounting at my church, and some people have taken the step to change their checks over to the trust, but that doesn't matter. The account, when I log online to my app, it says the Roberto and Becky Trust. When it comes to doing taxes, my wife and I still file married filing jointly, right? So that part does not change. It's just the ownership aspect of it changes, of those specific assets. So from day to day, I'll be honest, I forget I have a trust most of the time. When I get that county assessor's statement saying, here's what you're going to pay in taxes, that's when it really hits me. I was like, the Roberto and Becky trust. I was like, oh yeah, I forget my house is owned by the trust, right? But from day to day, you're not really going to see a difference, but your taxes and everything are just, it's just going to be basically like it is today. Does that answer your question?
You did, but like example, like we got some land in Lake Texoma, sell it sometime, but if we put that in a trust right now, so we go sell it, how does that mechanism work since it's now in the trust? I mean,
right.
Sell it just like we could.
Yes.
Instead of not knowing or.
Yeah. So the example is putting your house, like if you've got other properties like a lake home or land at Lake Texoma, right? You would transfer that via deed, transfer it into the trust, right? So your trust owns it, and let's say you do go sell it, then at that point you're going to sign your deed when you sell it to whoever buys it. You're going to sign as trustee of your trust rather than you individually, right? So you're going to be wearing your trust hat at that point. Now, all of that, if you do have a gain, right, that would all be reported with like your personal income tax return because it's tied to your social. Yes, sir.
Question, we discussing like property. Now, hypothetically, if me and my spouse was to accident and everything is in the trust about I have property, how do the kids, is it a blended family, and they try to disperse or sell the property, how does that work?
Right. So the example, the question is, there's a property, husband and wife, it is a blended family, right? Is it in the trust?
If you put
Once it's put in the trust, okay. Once it's put in the trust, whoever you and your wife had designated to take over, right? Let's say it's one of the kids. He's going to read the trust and say, what am I supposed to do with the house? If it says it's going to be split equally between the kids, then there's going to be a deed transferring it from the trust to the 4 kids. But I've had families that says, our kids do not get along. It would be a terrible idea to put them into equal ownership. So they said, okay, successor trustee, we want you to sell the house and split the proceeds. Or you can say, one of them can opt in to buy the house out of the trust, right? So there's options that we can work through there, but your trust agreement, your trust is going to dictate what's going to happen to that house. And for that matter, every other asset that you have, right? So, yes, ma'am.
I've been doing some research on trust. What is, and does Oklahoma recognize the spendthrift trust?
You can, yes, it is basically where you are limiting, in the situations where you're limiting the kids, what they're entitled to their share and what they're able to inherit and then spend, that's theirs. That's where you're putting those guardrails, right? And so yes, we can do that within your trust to say you're allowed to have this much, outright, or I'm going to provide you income every year for X amount of years. It's at that point you're getting very specific. But does Oklahoma recognize it? Yes, but it is the overall concept for a spendthrift is just to make sure that we are putting guardrails so that it's not completely just they don't blow it away. All right, their inheritance. Other questions? Yes.
Just out of curiosity, what are some examples of somebody contesting a will and winning? I mean, if I have a will saying this is what I want, this is my stuff,
right?
Then how can they contest it and win?
Right. So let's say like mom has dementia, right? And part of it is that you have to have the mental capacity to execute a will, and that will is executed after she's already been diagnosed with dementia, right? So she didn't have the mental capacity. That would be an easy one to contest, right? The one that we are contesting is we don't feel that there's 2 valid witnesses, We feel like the surviving girlfriend may have made up a name. We're not sure about the notary, right? So there are specific guidelines, things that need to be done according to the law that we don't feel meet that threshold has not been met. So we're attacking the notary and we're attacking the two witnesses. And the reason being is we represent the two sons, right? And they don't believe, we never knew that Dad had made a will. And all of a sudden, a couple of days before the hearing, something pops up. Like, oh, there's a will. Well, leaving everything to the girlfriend, right? So, very, very questionable. There's one up here. Any other questions? Yes, sir.
To dispel something I've heard, is there any truth that once you execute a trust or revocable trust or whatever, is there a time period that you still have to live? I've been told that you have to live 3 years after the execution for it to be legal without going into probate.
Okay, so the question was, does the trust have to be in place for a certain amount of time in order for it to be legal? The answer is no. It just has to be funded, right? And so we just include language that our trusts that we create are initially funded with $10, right? A lot of our clients have a house, right? And that same day, we're also putting the house into the trust. The trust remains valid as long as there's what we call a corpus. There's something that it owns. Once everything's out of the trust, like you distribute the house and the $10 and then there's nothing left, at that point, technically, it diminishes. It goes away at that point. But no, there's no legal requirement that it has to be X amount. You could execute it one morning, and if you put the house in there that same morning and you pass away at night, it's owned by the trust. More questions? Yes, ma'am.
If I get a trust,
Mhm.
and right now I have all my stuff in beneficiary forms with my kids, my 2 boys, and I want to do a trust,
Mhm.
and something happens to me before I can get all those beneficiaries changed to the trust.
Mhm.
Is that something you guys help, and it all becomes effective at the same time, or?
So that's what we call it. We talked about that funding matrix, right? So for us, we're real big. The other good thing about working with just someone who focuses on estate planning is that we've got a process. I was talking to an individual over Christmas, and they're like, yeah, we're putting a trust. I've been working with my attorney on the trust for a year. And I'm like, whoa, that's a long time. For us, we shoot for 3 to 4 weeks. Once you become a client, we want you guys within that time frame to come in and sign. And once you sign, we want to give you back your binder about a week later. All right, so for a lot of our clients, as long as we're not waiting on you guys to give us the information, because that's generally what happens if we fall outside, is we're waiting on something, right? We're having problems deciding on who the decision makers are going to be. But when you get your binder back, a lot of times we're doing the house. But that's like you said, you've got PODs on your bank accounts, life insurance. Those need to be updated. We will have a funding matrix where we're going to tell you, say, Kim, for your bank account, here's what you need to go do, right? And there is that period where if you were to pass away, it would default to your beneficiaries, right? We do have a client care program that we're about to start rolling out where we'll actually help you through that process, right? It is separate and apart, but some people are like, I don't want to, you help me through this, right? And so they choose to pay us to help them through that process. But we'll actively reach out to the banks and get everything set up to where the only thing you have to do is go in and sign, right? We'll help with the life insurance. We'll help with their 401ks. So we like to give our clients flexibility on what that process looks like. But ideally, once you get it set up, like you're good, you're golden, right? Me as an attorney, my wife threatened to leave me because I was dragging my feet on this. And she said, if you don't get this done, I'm going to leave you. So I threw something together. We got it done. Everything got switched over, right? I logged in as her because she didn't want to do it. I knew she wasn't going to do it. So she's busy. And I did everything, and then a year later I was like, did I update the life insurance? And so I went on there, I was like, I did not, right? So even as an attorney, I always had to remember, like, your funding matrix has all these little blue boxes, and your goal is to check every box off. I had not checked those boxes off. I was like, shame on me, right? So, but if you say, I'm gonna dedicate one account per week, or these types of accounts this week, I think that's the best way that you're going to check off through that list. So yeah, does that answer your question?
Yeah, what about the deeds? Like right now, I do have my boys, I have a house in Norman.
Mm-hmm.
Lived in when he was in college. And it's in my name with the 2 boys on in case I would die.
Mm-hmm.
So you help with getting deeds put into just the trust?
Yes. Yeah, and that's oftentimes, I had a conversation yesterday with a gentleman who was calling for his mom. She had 19 rentals. I was like, well, that's going to be expensive. I mean, but good on you that you've got 19 rentals. But the front part, the initial work, is going to be a lot of work. But once you get it set up, like if you've owned rentals, that's a whole different discussion that we need to be having, right? Because if you get sued at one of your rentals, now they're attacking everything that you own, right? So let's set up an LLC to protect your personal assets from your business adventures, right? So we've got 4 homes. I bought my childhood home from my parents here in Lawton, so I do own a rental here in Lawton. But it's in an LLC, not my personal name. But that's a whole separate, but yeah, we do deeds all day long.